My Lords, this morning I mentioned that there are certain liabilities in respect of which there is no interests requirement in the legislation. Those were omitted from the authorities bundle. I can hand up paper copies, or if my Lords would prefer, we can send electronic copies, whatever's easiest for the court. Just for
Well, should we have the paper, but it would be useful to have it electronically as well, if that's possible.
Certainly.
In due course.
Shall I provide them?
Yes.
Yes. So there's one each of those, and one each of those. So your Lordships should have part of Schedule 9B to the 1987 regulations. And there, the paragraph is paragraph 2. That's in relation to child support. And there, the deductions may be imposed. There is no requirement that the Secretary of State be satisfied that that is in the interests of the claimant. The second example provided is from the fines deductions from income support regulations 1992, and there it's regulation 4. Again, I'm not going to take time reading through the statutory language, but there deductions may be made without there being a precondition in relation to interests. Essentially, the interests requirement applies to housing, fuel, water, and miscellaneous accommodation costs, and those are all in Schedule 9, and obviously we've looked at provisions in relation to fuel and water. And then in relation to deductions where there's no precondition of interests, in addition to the two examples I've given you, fines and child maintenance, the same is true, for example, in relation to council tax, credit union loans, and a handful of miscellaneous others. And so it may be the case that in relation to those, that reflects a judgment, it clearly reflects a choice on the part of the legislature, that there may be some matters where it is sufficiently important that the deductions be made and the liabilities discharged, notwithstanding that it's not in the interests of the individual. And one can see why, for example, in relation to child maintenance, perhaps that might be the case. So we have that distinction in the various statutory frameworks.
It's not just a straightforward public-private split, no.
No, it's not.
Credit unions are private sector.
Yes, it's not, because for the council tax example, I haven't given you those, of course, but the relevant regulations are the council tax deductions and income support regulations 1993, regulation 5. We can provide those electronically as well. And of course, water and fuel companies are private sector organisations.
No, I was thinking the public sector might say, well, you've got to pay us, but these private sector people might not get such priority.
I don't detect that as being the reason, but in any event, the short point is just that the distinction reinforces, in my respectful submission, that what we are concerned with is where there's been a deliberate choice to make a precondition of the exercise of the power that it's in the interest of the individual.
In a sense, it doesn't matter why.
In a sense, it doesn't. My Lords, if I might then turn to the case law in relation to fairness. And so this is a response to my learned friends' grounds of appeal 1 and 2. If you can turn to the authorities bundle, and if I can start briefly with the extract from the case of Doody. So that's tab 22 of the authorities bundle. Starts on page 607, but the relevant passage is at page 636. I'm not going to read through the 6 principles, but there are just 3 points I wanted to emphasise. The first principle is the presumption where an Act of Parliament confers an administrative power that it will be exercised in a manner which is fair in all the circumstances. The second is the fact that the standards of fairness are not immutable and may change with the passage of time. And it will be my submission when we look at the more recent case law, there has been an increasing tendency amongst the courts to hold that prior notice, prior consultation is required. And then the fourth point, and Mr. Sheldon did take you to this, but I just wanted to emphasise one aspect of it. An essential feature of the context is the statute which creates the discretion, as regards both its language and the shape of the legal and administrative system. And I emphasise, for reasons which I'm sure will be obvious, the point there about the statute and the statutory language. If we then turn to the more recent case law, starting with Bank Mellat, which is in the authorities bundle at tab 10. With the judgment of Lord Sumption commencing on page 212. My short submission in relation to the Bank Mellat judgments is that there is no real difference between the approach of Lord Sumption, agreed with a number of his colleagues, and the approach of Lord Neuberger. If I can then just take you to a handful of the passages, so starting on page 223, so this part of Lord Sumption's judgment starts at paragraph 28. Paragraph 29 refers to the duty to give advance notice and the opportunity to be heard being one of the oldest principles of public law, and reference made to Cooper and Wandsworth Board of Works. There's then the citation from Doody, which we needn't repeat, and if my lords go over the page to paragraph 31, we'll see here a passage upon which I think Mr. Sheldon relied, picking up in the third line, it depends on the particular circumstances in which each directive is made. It's instructive in my submission to look at the examples Lord Sumption gives, because they chime with what's then said in elsewhere and in other cases. So the examples Lord Sumption gives of where you might not have a duty of prior consultation is where there might be, for example, have to be disclosure of secret intelligence, or it might result in matters that go to the heart of policy issues relating to money laundering or terrorism. So practical impediments, which is entirely consistent with what Lord Neuberger then says later. And then if we turn to paragraph 32 on page 225, we see the terms in which Lord Sumption expressed himself, obvious that fairness required an opportunity to make representations before the direction was made. And then there are a series of reasons there set out. Now, there are obviously reasons on the facts of the individual case, but they include significantly the impact on the entity which was the subject of the decision, so the serious effect that the decision would have, and that effectively is points 1 and 2 in paragraph 32. And then his third point is the absence of any practical difficulties in the way of an effective consultation exercise. And then the fourth point, which we see beside letter E on that page, is the direction not being based on general policy considerations, but on specific factual allegations of a kind plainly capable of being refuted. And we would respectfully suggest a similar point can be made in the current context. We're not here concerned with refuting allegations, but we are talking about a decision which is based upon the particular circumstances of an individual. And then it's important to flag up what Lord Sumption then says just above letter F. The principle which required this consultation is more than a principle of fairness. It is also a principle of good administration. And then skipping down to next to the letter G, the quality of the decision-making process at every stage would have been higher if the Treasury had had the opportunity before making the direction to consider the facts which Mitting J ultimately found. Lord Sumption then goes on to consider whether the duty that would otherwise arise at common law could be said to be excluded by the statute, and concludes that they were not. And if we just go over the page, again, I won't read through paragraphs 34 through to 35. Paragraph 36 Lord Sumption says, doesn't of course follow that a duty of prior consultation will arise in every case. And in my respectful submission, again, nothing inconsistent with what Lord Neuberger then says later. He doesn't suggest that that is the case. And then if we turn then to Lord Neuberger's judgment, page 265, picking it up at paragraph 178, so the bottom of that page, we can see he expressly associates himself with what Lord Sumption has said in paragraphs 29 to 30 of his judgment. And the reference there is the exercise of power to a person's substantial detriment. So looking at the impact on the individual, which is exactly what Lord Sumption had said. And then well established in the absence of special facts, the common law imposes a duty on the executive to give notice to that person of its intention and give the opportunity to be heard. And then we see citation of the two authorities which Lord Sumption had also cited. This is over the page. So Cooper and Wandsworth Board of Works and Ex parte Doody. And then paragraph 179, which is where my learned friend Mr. Sheldon suggests there's a distinction between Lord Neuberger and the decision of the majority. There is, in my respectful submission, no such distinction. Lord Neuberger's not saying in every single case before a statutory power is exercised there has to be prior notice or prior consultation. He's talking about cases in which a person who would foreseeably be significantly detrimentally affected by the exercise should be given the opportunity to make representations in advance. And he then also recognises that there may be circumstances in which that can't happen, again, entirely consistent with what Lord Sumption said, maybe because the statutory provisions impliedly or expressly exclude that, or it may be because there are circumstances that make it practically unachievable or very difficult to do so. So nothing there between the judgments. Paragraph 180 then refers expressly again to Lord Sumption's reasoning, as indeed does the end of paragraph 183, top of page 287, and paragraph 187. And again, paragraph 191 also picks up on the reasoning of Lord Sumption. So in my submission, Mr. Sheldon's submissions attempt to identify differences where in truth there are none. If we then look at two authorities which you haven't been shown, two subsequent authorities of the Supreme Court, at tab 17, page 476 of the bundle, you have the case of King and the Secretary of State for Justice. You will see if you turn to page 493, it's a unanimous decision of the Supreme Court. And then if you turn to page 512, you will see where the discussion on procedural fairness starts. I'm not going to go through the detail of the context in that case. It's about decision-making in relation to prison segregation. If we pick it up, bottom of page 421, please. You'll see in paragraph 96 the citation of Doody.
So bundle page number?
Page 513, my lord, my apologies. So paragraph 96 refers to Doody, and then paragraph 97 looks at the principles underpinning the law in relation to fairness, by reference to another Supreme Court case, the case of Osborne. More recently, in Osborne, this court considered the rationale of Procedural Fairness Act common law and emphasised both the instrumental value of enabling persons to participate in decision-making when they may be able to contribute relevant information or to test other information before the decision-maker, and the ethical value of allowing persons to participate in decision-making which concerns them and is liable to have a significant effect on their rights or interests, where they may have something to say which is relevant to the decision to be taken. And those principles, I would respectfully submit, an equally powerful application in the context with which this court is concerned. And then paragraph 98 then looks at the particular context before the court, says that a prisoner should normally have a reasonable opportunity to make representations before a decision is taken by the Secretary of State under Rule 45.2. Then instrumental justice, the reasons that are set out, that follows from the seriousness of the consequences, the fact that authority is sought on the basis of information concerning him, i.e. the prisoner, and the fact that he may be able to answer allegations made or provide relevant information. So 3 reasons there given: seriousness of consequences, exactly as set out by Lord Sumption and Lord Newburger. The fact that the decision is based upon information concerning the prisoner, I respectfully submit exactly the same is true of the context with which this court is concerned, and the fact that the prisoner may be in a position to provide relevant information. And again, I would say exactly the same is the position in relation to the present context. And then the second Supreme Court authority, I should say third, as we've looked at Bank Mellet, is the case of Mosley. That's behind tab 18, page 521. There are just 2 passages in the judgment of Lord Wilson. The first is paragraph 24 on page 531. And again, you'll see the reference there to the judgment in Osborne. And you'll see then, again, the Supreme Court endorsing what's said there about the importance of procedural fairness at letter C, liable to result in better decisions by ensuring that the decision maker receives all relevant information and that it's properly tested. And secondly, avoiding the sense of injustice, which the person who's the subject of the decision will otherwise feel. The third purpose, I think, is, although relevant to the context in Mosley, is less relevant to the person. And then over the page, paragraph 26, there are 2 further points made by Lord Wilson. So this is page 532 of the authorities bundle. The first point made in paragraph 26 is not particularly pertinent for us, but the second point, which is just between letters C and D on page 532, in the words of Simon Brown, LJ, and ex parte Baker, the demands of fairness are likely to be somewhat higher when an authority contemplates depriving someone of an existing benefit or advantage than when the claimant is a bare applicant for a future benefit. And when I seek to pull together the principles and apply them to the present context, that's one further point which I rely upon. So those are the approaches of the Supreme Court. I then take you to 2 authorities of the Court of Appeal. The second will be the Balajagari case, but the first is the case of Citizens UK. That's at tab 15 of the authorities bundle, page 392. It's the principal judgment is given by Lord Justice Singh, with whom Lord Justices Aspin and Higginbottom agree. Those second judgments start on page 415. If my lords turn to paragraph 68, page 399. We see, starting at paragraph 68, a discussion of authorities relating to the duty of fairness at common law, and the reference again there to Cooper and Wandsworth Board of Works, and the common law supplying the omission of the legislator. We then have cited Doody. I won't read that again, but if your lordships kindly go to page 400, and picking it up halfway down the page at paragraph 75, important to note that fairness is an objective question for the court to decide. And then paragraph 76, from the judgment of the Court of Appeal in RQ versus Secretary of State for the Home Department, which concerned the fairness of a process for determining whether a person had applied for asylum as soon as reasonably practicable after arriving in the UK, there can be derived the following propositions. 1, it's possible to challenge a system as being unfair and not only an individual decision. 2, fairness may require, as it did in the circumstances of that case, that the purpose of an interview should be made clear to those who are being interviewed. 3, interviewers should be given clear instructions about what they are to do. 4, it is not sufficient to say that the Secretary of State is willing to reconsider her first view and will always be prepared to reconsider an adverse decision. That is not a substitute for proper and fair primary decision-making. 5, before the decision-maker concludes that a claimant is not telling the truth, he must be given an opportunity of meeting any concerns, or at least he should be informed of the gist of the case against him. And then 6 is a citation from the judgment of Lord Justice Sedley in the Refugee Legal Centre case. Picking it up, 3rd line down into that quote, it is not entitled, that's the executive, to sacrifice fairness on the altar of speed and convenience, much less of expediency. Whether it's done so is a question of law for the courts. And then there's reference over the page, picking it up, I think, in the penultimate sentence of that extract about administrative convenience not justifying fairness. And then, from paragraph 80 onwards, the citation from the case of Osborne. I haven't put the Osborne before you, but you pick up the relevant passages from this and the earlier judgments. Paragraph 81, Supreme Court confirmed the proposition the test is whether there's been procedural fairness or not, it's an objective question for the court. Paragraph 82 refers to the underlying rationales for why fairness is important, so better decisions, avoidance of the sense of injustice. And then you have the quote from Lord Reed's judgment there set out, the importance of participation and paying respect to those whose rights are affected. And then paragraph 83, fairness is conducive to the rule of law. And then again, a quote from Lord Reed, procedural requirements that decision makers should listen to persons who have something relevant to say, promote congruence between the actions of decision makers and the law which should govern their actions. And then we see a discussion starting at paragraph 85 about the application of those principles to the facts of the case. I don't propose to take you through those, but you'll see in paragraph 85 the discussion in relation to where the opportunity to make representations is not given before a decision is taken. What Lord Justice Singh is there identifying is essentially that's something that will be appropriate only where there are good reasons for that to be the case, such as urgency or the need to maintain confidentiality. And in our respectful submission, no good reasons have been advanced by the Secretary of State as to why there cannot be a prior opportunity to provide information. I should just, finally, before leaving this authority, ask you to look at paragraph 94 on page 403, in which, referring to a submission that was being made by Sir James Edis, Lord Justice Singh says this at paragraph 94, the first flaw is that it assumes that fairness is not required at an earlier decision-making stage, simply because fairness is required at a later decision-making stage. I would not accept that as a matter of principle. In my view, in principle, a person is entitled to be treated fairly at all relevant decision-making stages. And then we finally come to Balajigari, which is tab 14, starting on page 331. And we can see from page 338, first paragraph, although the judgment is handed down by Lord Justice Underhill, it's a judgment of the court, so it's a judgment as well of Lord Justices Singh and Higginbottom, both of whom had been involved in the Citizens UK case. If you turn to page 348, you'll see the discussion on procedural fairness starting towards the bottom of the page, paragraph 45, where there is extensive citation from Citizens UK. We've just looked at it, so I don't need to go through that. If your lordships go over the page to page 350, you'll see this Court of Appeal emphasising what had been said by the Court of Appeal in Citizens UK at paragraph 47, the underlying rationales for why fairness is important. And then there's a discussion of the ex parte Fayed case, starting in paragraph 50, but if I pick it up the top of page 351, the reasons that are given in paragraphs 50, 51, 52 and 53 by the court in Balajigari for concluding that fairness required certain steps to be taken, focus on the impact on the individual who is the subject of the decision. So entirely consistent with what we've seen in the thread of all the authorities and what's said both by Lord Sumption and by Lord Newberger and Bank Mellat. And then going to what from Mr. Sheldon's perspective is the offending paragraph, bottom of page 351, paragraph 59, there's an express recognition there that the duty to act fairly may not always require steps to be taken before a decision is reached. What we then have set out is fairness will usually require that to be done where that's feasible for practical and other reasons. That's entirely consistent in my submission with everything that we've seen. There's then the citation from Lord Newberger, and then paragraph 60, what's then set out by the Court of Appeal unanimously, unless the circumstances of a particular case make this impracticable, and that's, again, it follows through the thread of the case law in all the cases that we just looked at, the ability to make representations only after a decision has been taken will usually, I'm not saying invariably, but usually be insufficient to satisfy the demands of common law procedural fairness. And then the court goes on to explain why that's the case, and it's because of the underlying rationale for procedural fairness. You get better decision making in the first instance, you are showing respect to the individual if they are involved from the outset, and then the third point is the point in relation to potential defensiveness or confirmation bias. But it's an impeccably reasoned judgment in my respectful submission, nothing in it that is inconsistent with any of the earlier authorities, and perfectly appropriate for Mr. Justice Cavanagh in the court below to have referred to it and relied on it. And he had, I think with the exception of Citizens UK, all the authorities before him that we've looked at. So turning then to the submissions of Mr. Sheldon in relation to fairness, the first point, for the reasons I've set out, is there was no error of law on Mr. Justice Cavanagh's part. If I'm wrong about that, in any event, if for some reason he misunderstood what Lord Justice Underhill was saying, or Lord Justice Underhill understood what Lord Newberger and Lord Sumption were saying, looking at the tenor of the authorities as a whole, it's absolutely plain that this is a case in which fairness required there to be an opportunity to be given to the claimant to set out matters relevant to their interests. Bearing in mind point 4 in Lord Mustill's judgment in Doody, the relevant statutory and factual context, just have a series of short points to make. Firstly, in this context, the claimant, the benefit claimant, is directly and individually affected by the decision. Secondly, the decision is of real and significant importance to the claimant, as Mr. Justice Cavanagh accepted. And as the respondent's evidence illustrates, a deduction can have a significant detrimental impact on a benefit claimant's daily life. Thirdly, this is a case involving a decision that takes away something to which the benefit claimant's entitlement has already been established. So it's a Moseley paragraph 26 case, taking away an existing benefit rather than the potential conferral of a new benefit, and the standards of fairness are therefore all the higher. Fourthly, the statutory framework places the claimant's interests at the centre. That's the criterion that has to be satisfied, or the family's interests. And this is therefore a context in which the claimant is obviously not only well placed to know what those interests might be and to provide information relevant to the decision which the Secretary of State has to take, but there is unlikely to be any equivalent source of information about interests. Fifthly, although, of course, the Secretary of State is entitled to look at the information that's provided by the utility company, they are neither a neutral contributor of information, because they want the deductions, it's in their financial interest, but nor are they realistically going to be in a position to provide information in many cases about an individual's interests. They're not going to know about that family's personal circumstances. And in other cases, or other circumstances, where a decision maker was making a legally binding allocation of one party's resources to another, for example, a court or an arbitrator, it would be an elementary requirement that both parties would have an equal opportunity to make representations before a decision is taken. And then finally, if one goes back to the reasons identified in the case law, good administration, better decision making, that is undoubtedly enhanced by providing an opportunity to the benefit claimant to make representations, avoidance of the sense of injustice, and the promotion of the rule of law. I've already addressed you on why I say Mr. Sheldon's submissions about what happens before the decision is taken don't answer the point, so the pre-engagement and the material in the spreadsheet don't answer the point. If I can just briefly deal with what he says about post-decision representations, he relies heavily on the scope for mandatory reconsideration or revision, to use the statutory term. That puts the burden on the claimant to take steps in circumstances where the statutory framework requires the Secretary of State to be satisfied in the first place of their interests. In our submission, the judge did take proper account of the potential for deductions decisions to be revised or superseded or reversed on appeal, but those are non-suspensive remedies, and the effect of a deduction may be immediate, will be immediate, and maybe potentially impose significant practical constraints upon the benefit claimant's ability to manage. And so it's no answer to say, well, they can go through the reconsideration route and challenge the decision. I think the best information we have from Mr. Sheldon is that 47 days is the median from receipt of the request for mandatory reconsideration to it being undertaken.
When the decision is made to deduct, is a letter then written to the beneficiary of the benefits of the recipient?
So that is supposed to happen. Ms. Waterman's statement says that's something that should effectively be generated as almost automatically. The respondent's evidence was that certainly in the past that had not been her experience. But Ms. Waterman says yes, a letter is generated.
And does it inform of the right to a reconsideration and indicate what the statutory test is?
I'm going to have to check. In terms of the reconsideration, yes. No. I think we had a sample letter in the bundle in the High Court, which I'm not sure that we have in the appeal bundle, so maybe we can find that. My recollection of it is it does refer to mandatory reconsideration. It refers to appeal rights, but our recollection isn't that it sets out the statutory test. But we'll obviously check what we have.
Is the revision, is that dealt with, is that the result of Section 9 of the Social Security Act 1998? That's the power,
yes, it's...
which is at page 12 of the authorities bundle.
Yes.
Because I don't think we've actually looked at this in detail yet.
Yes, so the revision powers are set out, yes, in Section 9 on page 12 of the authorities bundle.
Now, in 9.2, says the Secretary of State need not consider any issue that's not raised by the application. Is that it? So that means that at the first stage, the Secretary of State has to consider whatever the Secretary of State has got to decide the interests of the family. But at this stage, the revision is limited to matters raised in the application. Is that right, or is that wrong? Don't quite know. I just don't have an instinctive feel for how this process actually works.
No, I'm just going to turn my back if I may. I mean, I'm not sure that there's an answer beyond the words of the statute, my lord. No. The Secretary of State doesn't have to consider matters that haven't been brought to his attention by the person making the application, is what Section 9.2 would suggest. In practice, it is supposed to be looking at the question again. I don't think we have any of the relevant guidance or case law before in the bundles before the court. But it's not limited to a kind of judicial review type exercise, a revision or reconsideration process. Our submission as to why it isn't sufficient is effectively tied to all the principles articulated in the case law that I've taken my lords through, and then the fact that it requires action to be taken positively by the claimant, who may know nothing about what the statutory test is, and then it introduces a period of delay. Whereas the requirement in the Act is the Secretary of State has to make that decision in the first place. He is not legally empowered to make a deductions decision unless he can be so satisfied.
I've just been looking at the judgment. I don't think there's a finding about what claimants are told beyond the one in paragraph 90, where the judge resolved a dispute between the parties over what happens once the TPD has been put in place. He found the claimant will automatically be notified in writing once the TPD has been put in place, which is step one. But I don't think there's a finding about what else, if anything, is communicated to the claimant at that point. No,
and we will check what letters were in the bundle before Mr. Justice Cavanagh. As I say, my recollection is that it doesn't spell out the statutory test, but it does refer to mandatory reconsideration.
Because one of the points that's made against you, and maybe this is in another part of your argument, is that I think the figures are roughly 200,000 people on TPDs for water and 4 complaints.
Well, those are, first of all, those are not complaints to the DWP.
No, they're not.
They're complaints to a statutory
water.
council.
Yeah.
We know nothing about the subject matter of those complaints.
But the evidence is recorded, I think, in the next paragraph of the judgment, is Ms. Waterman said that in practice mandatory reconsiderations are rare, so that's also
yes,
a low
of course.
number.
So they may be rare for a number of reasons, none of which were set out in the evidence before the court below. They may be rare because people don't realise their significance, because people don't understand, they're not being told what the test is. They may be rare because the practical reality of life as a benefits claimant struggling day to day is you don't think to challenge things because you are just getting on with trying to manage the best you can. Most claimants may not have the determination and grit that the respondent in the present case and the sense of injustice that the respondent in the present case had. But there isn't an inference that can be drawn in my respectful submission from either the number of complaints or the number of mandatory reconsideration cases. We know from Ms. Waterman's evidence and from the notes that one of the flaws exposed by Ms. Timson's case had been claimants were wrongly being told there wasn't a mandatory reconsideration route. Ms. Timson herself had contacted the DWP in April 2021 or spring 2021, essentially raised her objections to the deductions being imposed and was told in terms, well, that's nothing we can do about that by the DWP, go away and see speak to the utility supplier. And she explains that further in her statements. it is accepted by the Secretary of State and was accepted by Ms Waterman that that was wrong. But it's hardly surprising that there are a few mandatory reconsideration cases. If people were being told that if they raised objections to deductions, tough, go and speak to the utility supplier.
Well, the benefits recipients know and accept that they owe the money to the utility company. They're told by the utility company's got a right to ask the department to take it from the benefits. They then receive notification from the government that it is going to deduct from the benefits to pay the debt. It probably won't occur to most of them there's anything they can do.
Yes.
Or that they've got any argument at all.
Absolutely.
Unless until somebody says to them, well, actually, there is an overarching consideration here which you might want to address.
And there's every difference between that and the Secretary of State writing to the individual saying, we have received an application for deductions to be made, and this is the test that has to be satisfied. Please tell us anything you want to relevant to that. And it's a completely different matter. If, in those circumstances, claimants elect not to respond, then of course the Secretary of State is entitled to proceed upon the basis of the material that he has.
Well, I can see it could be quite disappointing for the utility companies and possibly also for the department if they received back a number of representations from customers, benefit recipients in those circumstances. But then, so be it.
So be it, exactly.
They'd have to deal with them. But then why shouldn't they deal with them, is what you would say?
Yes.
People have representations to make as to why it's not in their interests. That's the statutory question.
Exactly.
And really what's being said here is this is absolutely an example of the of it being said that expediency overrides fairness.
Yes.
It would be awkward to have to deal with these representations or the right to make representations.
Yes, exactly. And that takes us back again to the principles which underpin the right to prior notice in the first place, in terms of sense of injustice and good administration.
Sorry, can I help, my Lord, just on the factual point of what the letters say? Because I'm looking at what was in the letters before the Mr. Justice Cavanagh. They do inform the claimant of the right to seek a mandatory reconsideration. They don't set out the statutory test, but they say that you can ask us for an explanation of the decisions or ask for a written statement of reason for the decisions if we haven't already sent you one. So no setting out of statutory tests, but indication of you can ask us if you.
This is a letter from the DWP.
To the benefit claimant saying we're taking deductions.
Thank you.
So for those reasons and the reasons set out in our skeleton argument, we say Mr. Justice Cavanagh was right to conclude that fairness required a prior opportunity to be given to benefit claimants, and required in all cases, unless there are, for example, one can think of exceptional cases where consent may be apparent from material that the individual holds, or the application is being made directly by the benefit claimant. But otherwise, and I'll come on to the question of rare cases and numbers of cases in due course, but even assuming that it will only be a small number of cases where the Secretary of State decides it's not in the interests of the claimant to have the deductions made, you cannot identify those cases without, in all instances, providing the opportunity. Can I then come to the Tameside argument? That's the principle of public law that a decision maker must make reasonable attempts to obtain the information necessary for their decision making. Can I just show you Tameside briefly? It's in the authorities bundle at tab 23, page 645. And the relevant passage in the judgment of Lord Diplock is just at the top of page 696 at letter B. question for the court is, did the Secretary of State ask himself the right question and take reasonable steps to acquaint himself with the relevant information to enable him to answer it correctly? I think need to take you back to the passage in Balad-Kajari, which Mr. Sheldon showed you. That drew on the Plantagenet Alliance case, which you have in the bundle. I'm not going to take you to it, but it's behind tab 19, and the relevant passage is paragraph 99 and 100, pages 560 to 561. We accept that it is here a Wednesbury test, so it's unlike fairness, it's not for the court to decide the information that needs to be gathered. It is a question of whether the decision makers made reasonable attempts. However, the short point here is, given the statutory context and the precondition to the making of deductions, the Secretary of State can't possibly rationally be satisfied that something's in the interests of the family without seeking information about those interests. And he doesn't do so at all from the benefit claimant, as we know. And the information that he seeks from that he receives from the supplier through the spreadsheet is insufficient to enable that question to be answered. Usually, the Secretary of State will have no real information about interests other than general assumptions about the desirability of not running up debts and so on. But in terms of the individual interests, none of the material available is likely to cast any light on that. And so this is, we say, a clear and open case of tame-side unlawfulness, where in reality the Secretary of State makes no meaningful efforts whatsoever to obtain the kind of information that would have to inform the exercise of judgment. My learned friend said, both in relation to the tame side argument and in relation to the argument based upon the A case, relying upon Mr. Justice Kavanagh's suggestion that it'll only be in rare cases that it won't be in their interests to make deductions. He said, well, it can't be said to be tame side insufficient in every case. But that is, in my submission, conflating the outcome with the process of lawful decision-making. We've made this point in paragraph 55 of our skeleton, and it's a point my Lord's picked up in discussion with Mr. Sheldon. We say the statutory framework will require inquiry in every case, unless, as I say, it's known that the claimant consents or the claimant's making the application. You can't identify which will be the cases in which it's not in an individual's interests unless you make that in advance or in the abstract. You have to make the inquiry in every case. And then, as we've set out in our skeleton, we've identified the kind of factors that we say would be relevant, taking the respondent's case as an example, an illustrative example, relevant to the question of whether deductions were in the respondent's interests. And I'll just briefly summarise those. The fact that because of her circumstances she wasn't at real risk of disconnection or prepayment meter. The fact that because of her particular circumstances she was not concerned about court proceedings or debt recovery action, implausible on the facts in her case in any event. The fact that she had other liabilities and was more concerned about maximising her income than paying off debt fast, so she wanted to repay any arrears, not ignore them, but repay them at a lower rate than available under the TPD scheme. The fact that she had other competing needs from time to time essential to her welfare. The importance to her of flexibility so that she could meet unexpected needs from day to day and give her a sense of control over her life. And then the impact on her individually as someone with substantial mental health problems, the distress, stress, and thoughts of self-harm that were occasioned. All those matters would plainly be relevant on the respondent's own case. Of course, there will be plenty of individuals in respect of whom either different considerations apply or none of those considerations apply. And of course, it is the case that the Secretary of State did supersede his decisions in relation to the appellant in July 2021. For those reasons, in sum, we say that the judge was right to conclude that the system set up by the Secretary of State was in breach of the Tameside duty of sufficient inquiry. Can I then turn to the policy issue and the significance of the Supreme Court's judgment in the case of A? And if the court would kindly turn that up, tab 13 of, no, wrong tab, sorry. Tab 12 of the authorities bundle. It starts on page 277. Before we look at paragraph 46, which Mr. Sheldon took you to, can I invite your attention to paragraph 43 on page 296? So if we pick it up in the second sentence of paragraph 43, the first claim brought by the appellant to challenge the guidance is an example. In its original form, the guidance did not tell decision makers to consider seeking representations from a subject before a disclosure to the public, but nor did it tell them not to. However, reading the guidance as a whole, it was clearly intended to set out for decision makers a reasonably complete decision-making procedure to be followed. So in our view, the Divisional Court was right to hold that, read objectively, it misdirected decision makers as to how they should proceed by implicitly indicating that they did not have to invite representations, whereas in many cases they had a legal obligation to do so. So our case is really foursquare on terms with what's set out in paragraph 43. If we then turn to paragraph 46 and pick up between C and D, the category 3 cases, I just want to read on from what's said there. So category 3 is described as where the authority, even though not under a duty to issue a policy, decides to promulgate one, and in so doing purports in the policy to provide a full account of the legal position but fails to achieve that, either because of a specific misstatement of the law or because of an omission which has the effect that, read as a whole, the policy presents a misleading picture of the true legal position. In a case of the type described by Rose LJ, where a Secretary of State issues guidance to his or her own staff, which is obviously what we're concerned with, the context is likely to, explaining the legal framework in which they perform their functions, the context is likely to be such as to bring it within category 3. The audience for the policy would be expected to take direction about the performance of their functions on behalf of their department from the Secretary of State at the head of the department, rather than seeking independent advice of their own. So read objectively, and depending on the content and form of the policy, it may more readily be interpreted as a comprehensive statement of the relevant legal position, and its lawfulness will be assessed on that basis. And then it draws a distinction between that scenario and then the scenario that was before the Supreme Court, where it was guidance to the police independent of the Secretary of State. And then if we just turn to the passage at the top of page 304, so it's paragraph 63, and this is the reference to material and identifiable number of cases, which Mr. Sheldon repeatedly relied on, between A and B on page 304. It is not clear to me exactly what the Supreme Court have in mind when they talk about a material and identifiable number of cases. It seems implausible to expect challenger or a court to be able to identify in advance the number of cases that might be affected by what is or isn't set out in a policy. And one notes the very bottom of that page, the court says this: the test for the lawfulness of a policy is not a statistical test, but should depend on a comparison of the law and of what is stated to be the behaviour required if the policy is followed.
I wondered if the last sentence of paragraph 63 might mean a material number of cases and an identifiable class of cases.
That may be right, Phil. That would certainly make more sense.
And material as opposed to immaterial.
Yes. But the point here in our respectful submission again is my learned friend's reliance upon Mr. Justice Cavanagh saying what will only be in rare cases that you actually find that it's not in the interests of the individual to make the deductions, is putting the cart before the horse. What we're talking about is not the outcome if a process is followed, but whether the process should be followed. That's the defect in the policy. And there is a material and identifiable cohort of cases because it's effectively all cases, save possibly a very small number where you know from other material that consent is forthcoming. It's all cases for the reasons I've already given, of benefit claimants in respect of whom an application for third-party deductions where there's an interest requirement has been made. So we fall four square in my respectful submission within that part of A. If I can just take you briefly to the guidance in the supplemental bundle. In fact, before we look at the guidance, if we can go to the judgment, so tab 9 of the core bundle, and it's paragraph 67. Lords, I'm not sure my numbering is the same as the electronic numbering, so I have it at page 101 of the core bundle. It may be page 103 electronically. But in paragraph 67, Mr. Justice Cavanagh sets out some passages from the DMG, the Decision Makers Guide, which aren't in the bundle. So that's the reason for taking you to this. I have separately got copies of paragraph 01001 to 6, but I think we can take it from the judgment. So paragraph 01001 of the DMG refers to decisions on claims and applications being made by the Secretary of State, and then reference to the Cartona principle being made on his behalf by officials. And then it's paragraph 01003. The Secretary of State provides training and approved guidance to DMs on how to make decisions on their behalf. The DMG itself is one such form of guidance advising DMs how to apply the relevant law. DMs should note that approved guidance must be followed when applying the law to the facts of the case. However, DMs may request advice from DMA leads on the application or clarification of the DMG in cases of doubt. So the introduction to the Decision Makers Guidance, therefore, makes clear the status of this guidance and the purpose of this guidance. It's to tell decision makers how to go through the decision-making process. When we then get to the relevant parts of the DMG that deal with third-party deductions, and you have that in the supplemental bundle behind tab 30, starting on page 261. What you have, and I'm sure the court will have read it, so I won't go through it to prove what's not in there. But what you have is a fairly detailed articulation to the decision makers as to what they should do. What's described as the rules for third-party deductions start on page 270. There's reference to interests of the family, which do introduce a number of presumptions, but leaving that aside for present purposes. And then we go over the page, we can see 46307, 46308 sets out certain matters that the decision maker should consider, there's nothing in the DMG that directs decision makers to make any contact with claimants or afford them an opportunity to set out their view of their interests. If one looks at paragraph 270, sorry, page 277, under the heading superseding the third-party deduction decision, there's the assertion in paragraph 46352 that you shouldn't supersede a decision where the only reason is the claimant wishes to take control of the budgeting. That's not said to be a relevant change of circumstances. And then some examples of relevant change of circumstances are set out. And then we get water charges dealt with over the page, again in similar terms. But nothing which directs decision makers to what is, if we're right on fairness, the legal requirement to consult the claimants. We then have the overview at page 288. Paragraph 1 explains that it gives an overview of the principles and general rules of the third-party deduction scheme, including general rules. If we go over to page 291, under the heading Content of the Application, paragraph 24, it said there should be enough detail to correctly identify the customer. Then what to do when an application is received. And then heading further information needed on the top of page 292. So this is as good as it gets. Paragraph 26, consider contacting the relevant third party or the customer by telephone for any further information. Well, that falls far short from what we would say, applying the A case. It was the required statement of law that the claimant has to be contacted, whether by telephone or letter is immaterial for present purposes. And then it's interesting to note paragraph 33, towards the bottom of page 292. This list is not exhaustive. That's a list of factors that may be relevant to interests. And the DM should not assume that TPD would not be in the interest of the family because the customer is single or a member of a couple without children. Any representations made by the creditor as to the customer's circumstances should be taken into consideration when making the decision. So again, one-sided, no reference there to the making of representations by the benefit claimant. And we see that over the page again, repeated, so page 293, paragraph 37 under the heading Outstanding Debt Recovered. Where the outstanding debt's been recovered, the DM should consider whether TPD for current consumption only should consider. This should take account of the following. And the fifth bullet point is any representation made by the creditor. And then we see page 294, paragraph 46, TPD should not be stopped because the customer requests this. But that doesn't constitute a relevant change of circumstances. So nothing in my respectful submission in the guidance to decision makers that sets out what we say is the correct legal position. And for those reasons, Mr. Justice Kavanagh was absolutely right in the conclusion that he reached on that point. Just in relation to Mr. Sheldon's submission on these issues, as I understand it, he had a fallback submission to the effect that the guidance, because it didn't prohibit making contact with the individual, was capable of being implemented lawfully. If it had said something about obtaining the relevant information from the supplier, it wasn't entirely clear to me, and the fault may be mine as to what that submission amounted to. But relying upon something that isn't in the guidance doesn't appear to be a helpful way of justifying the lawfulness of the guidance.
I think the argument wasn't it, if the suppliers were to ask the right questions of the customer on their forms, which were then, and then that information was then supplied to the department, the guidance would then work because they would have the information that they needed. I think his argument was it could work if the suppliers asked the right questions.
Yes. Well, I mean, the answers to that are several-fold. First of all, that isn't what's done. So that's a hypothetical scenario and can't justify the lawfulness or otherwise of the current state of affairs. Secondly, for reasons which I hope I've set out sufficiently clearly already, asking the supplier to provide that information would not be a discharge of the common law duty of fairness, because the supplier has different interests and isn't likely to be in a position to know what the benefit claimant might wish to say. And the rationale for the common law duty of fairness, and goes back to the authorities I've taken my lords through this afternoon, includes the person who is at the heart of the decision, whose interests are affected, being given an opportunity to participate in the decision-making process. That's just not met if you say, well, let's go to the supplier. It does seem an extraordinary submission and an extraordinary state of affairs where the Secretary of State wants to do anything he can other than ask the one person who is most directly affected and whose interests lie at the heart of
But the Secretary of State could have a system which in practice required a supplier to ask the question that on your case should be asked by the Secretary of State directly, and then to use that as a mechanism for informing himself of all the relevant matters, or to discharge the Tameside duty and the duty of fairness through the supplier. I know that's not what's happening.
No, it's not what's happening. I can just about see how, if that was what was happened, it might be said to fulfil the Tameside duty of sufficient inquiry. It would not, in my respectful submission, even if that was the position, fulfil the duty of fairness, because it's still what a claimant might want to say to a supplier who is pursuing them for debt, who might be threatening to take them to court, who might say, well, you know, if you don't go down this route, the bailiffs will be coming round. Whether they are going to feel able to discuss what might be deeply personal circumstances.
I think what I had in mind was a one-stop arrangement where the supplier says, we're going to apply for a TPD, all other efforts have failed. If you have anything to say in response to that, tell the Secretary of State why it's not in your interest. That's not quite how I put it to you before, but that would be a variant. Of course, your answer will be that's not what actually happens, but I can see that might be a way of discharging both those duties.
So it's a letter in identical format to that which effectively I referred to earlier, but the sender of the letter.
I put it to Mr. Coppell, outsourcing the actual function, but thereby obtaining the information.
So the sending of the letter, the mechanics is that the utilities company sends it rather than
as part of what it's going to do anyway, or would do.
It is possible that a system could be constructed in that way, I suppose. It's not the system, and it seems a very artificial and an odd way to go about it. If it's the Secretary of State and not the utility company that's under the statutory duty to gather information and is under the statutory duty to act fairly and to satisfy himself as to the interests of the individual.
I suppose that in a sector where the supplier is licensed and regulated, it might be quite a complex calculation as to how they can participate in the process without rendering it unfair. And if we perhaps got to the stage of saying what was being done in this case was unfair, we probably wouldn't set about designing a system which might be fair in its substitution for it.
No, I would invite the court not to.
Yeah.
Yes, Mr. Royston rightly reminds me that whilst we've got, in terms of the actual deductions in this case, large organisations, So we've got Severn Trent Water, we've got E.ON. There may be much smaller organisations who are involved, particularly if one thinks about housing, small landlords, because housing is another one of the debts where there's an interest criterion in the regulations.
You now have some quite small energy providers as well.
Yes.
As we've discovered late.
Yes, absolutely. Can I then turn to Mr. Sheldon's fourth ground of appeal, the perversity challenge?
Well, that was pursued with a very light touch orally.
Yes. Well,
maybe that it would be appropriate for you to respond in similar.
I'm proposing to respond solely by referring you to what we set out in our skeleton argument. It's paragraph 60 of our skeleton. I'm afraid I don't have the reference where it appears in the bundle, but we say essentially it's based upon a misreading of the judgment. The judgment read in context makes no error whatsoever, or errors whatsoever, still less material errors capable of affecting the outcome. And so we really say everything that we would want to say about that ground of appeal in paragraph 60 and 61 of our skeleton argument. Lords, can I then turn to our respondent's notice arguments, which essentially the judge took an overly restrictive approach to what's meant by interests. My learned friends have characterised this as a challenge to the judge's factual findings and said, well, challenging factual findings in the Court of Appeal is an uphill struggle. But in my submission, it's not really correct to characterise them as factual findings. The question of interests really is a matter of statutory construction. The statute is, as I've already indicated, contains no specific definition, contains no limitations. And it wasn't the function of the judge in the court below to make factual findings about what might or might not constitute interests, or might not in individual cases, none of which were before him, give rise to a decision that deductions were or were not in the interests of an individual. So the real point in relation to the respondent's notice is that in circumstances where you have a broad term in the legislation, clearly capable of a wide meaning and focused upon the individual circumstances of the benefit claimant, the judge was wrong in principle, effectively then to attempt to give it a narrow meaning and to identify the kind of circumstances that the Secretary of State should or should not take into account. The Secretary of State should be taking into account anything that's relevant to an assessment of an individual's interests. And that's plainly capable of encompassing a wide range of factors, which would have to be looked at on an individual case and should not be a matter either of generalisation or of generalised assumptions. In terms of the suggestion that it would be in rare cases when it would not be in the interests of an individual for deductions not to be made, that's an assertion that really wasn't one that was open in my submission to the Secretary of State to make or the court to accept. In circumstances where the evidence is clear that for many years, the way in which the scheme has operated, as Ms. Waterman effectively accepts, was such that the Secretary of State didn't have relevant information about interests. And so it's essentially would be speculation, either for the Secretary of State or for the court below, to say how many cases there might be in which it might arise that deductions were not in an individual's best interests. That's a judgment that falls to be taken on the facts of an individual case. And until recently, on the admitted state of the evidence, even if I'm wrong about everything else, the spreadsheets or other information simply wasn't there for interests to be assessed. So really, the heart of the respondent's notice point is to invite this court essentially not to give its own dissertation on what might or might not be encompassed within the question of interests. But to find that Mr. Justice Kavanagh was wrong in principle, to effectively seek to fetter the wide discretion conferred by the legislation and give a, in my respectful submission, unhelpful gloss on the statutory language. We have set out in our skeleton argument a number of detailed reasons why we say he was then wrong in particular in the way in which he approached it, but the overarching submission is the submission I've just made. In relation to the skeleton argument, I don't want to take time going through it unless it would be of assistance to the court. But we set it out from paragraph 29 onwards of our skeleton argument.
You can read the page.
I'm sorry, let me just find it. I'm told it's page 54. Yes, page 54. Thank you. And really, the point is captured in paragraph 30. There are more circumstances, and this is really as a matter of construction and common sense than the judge recognised, in which deductions will be or may not be in a claimant's interests. And then we've set out from paragraph 32 onwards a number of detailed submissions, some of which I've already essentially set out in my address to the court this morning. So if I just highlight a handful of paragraphs, and then if the court would be assisted by anything further or has any particular questions, I will obviously deal with those. So paragraph 32, we say the judge was wrong to say it would run counter to the legislative purpose to say it's in the interest of the claimant to permit them to give preference to other financial obligations. Whether it's in the interest of a claimant to do so in an individual case will depend upon the facts of that individual case. It's not a subset of matters that can be carved out from the legislation as the judge purported to do. And the example we've given there is an example in relation to food and medical appointments.
Well, that interpretation of the legislative's purpose seems to omit or forget the 25% cap.
Yes.
Because plainly that recognises that there may be other calls on the benefit, which at least as far as the 75% are deemed to be more important than the utility bills.
Yes,
or maybe.
And also, in my respectful submission, that the way in which the regulations are drafted, which don't seek to say it's only certain types of interests, but talk about the interests of the family in an entirely untrammelled way. It would have been open to the legislator to say there's only certain types of interest, or you can only consider the competing liabilities as between those matters which can be the subject of third-party deductions, or to have no interest requirements at all. But the legislature has chosen to put in that very open-ended wording in the interests of the family.
It was interesting that we saw in some of the documents that the Secretary of State is meant to consider, or the decision maker is meant to consider, whether the family has alternative means of heating and cooking.
Yes.
It's an extraordinarily granular
yes.
aspect of consideration in terms of interests. Is it their interest? Is it in their interest that they deduct from the benefit to pay their heating bills, or do they have alternative means of cooking?
Absolutely, and that granular approach is the right approach, or in principle at least. Of course, there may be plenty of cases where it doesn't arise, but there may be all sorts of matters which are self-evidently of vital importance to an individual. It might be a broken household appliance, it might be food, it might be paying the rent shortfall, all the kind of examples, getting to a medical appointment, whatever it might be, which it can't possibly be said that's something that the legislation excludes the Secretary of State from considering. And so that's where the judge, in our respectful submission, has erred. Then set out in paragraph 35 onwards matters relating to the challenging level of benefits. I've dealt with that in my oral submissions this morning, so I don't think I need to repeat those. Perhaps just flag up paragraph 38. Again, it's reflected in the submissions I've made already. But the court below was wrong in my respectful submission to make certain assumptions that certain things will be worse for an individual than other things. That really was the court putting itself in the position of the Secretary of State as decision maker, and then, as I've indicated, taking an overly narrow approach to the legislation. And so I'd flag up the matter set out in paragraph 38 of the skeleton without repeating them. It is important to know, to set out there and in paragraph 39, that it is a perfectly proper matter to fall into an assessment of interests, whether enforcement action is realistic or not. And the question is asked, and my lords have already had a discussion with Mr. Coppell on this point, questions asked in the spreadsheet about enforcement action, presumably because the likelihood of enforcement action taking place is regarded by the Secretary of State as a relevant factor. We quite understand why it's a relevant factor. But whether that's actually something that's going to happen in practice is equally a matter that the Secretary of State would need to have regard to. Because if there are other demands in order to meet daily living needs on a claimant at a particular point in time, and the adverse consequence to them is essentially no more than the debt continuing to exist or accrue, because there is no realistic prospect of enforcement action being taken against them, then that's a matter that should factor into the decision-making process. And again, the judge's approach was really to try and carve out areas in a way that was unjustified. And then paragraph 42 onwards is the issue in relation to flexibility, which I hope is sufficiently and clearly set out in our skeleton argument 42 through to 44. And then the position in relation to autonomy, control over finances. We've never suggested that would be a decisive or determinative factor, but to suggest that it's not a factor relevant to the assessment of interests. Again, the judge, in my respectful submission, went wrong there. And then finally, paragraph 47, I alluded to this earlier, the order of priority rules in the regulations. The judge there, again, misunderstood in our respectful submission the purpose of that hierarchical provision in the regulations, which is essentially set out in paragraph 47C of our skeleton.
The question isn't whether it is reasonable of the claimant not to pay their bills, but whether or not it is in the interests of the family as a whole to deduct the bills from the benefits.
Yes.
And that is a different question.
Yes. Yes. And that there may be a different range of circumstances that fall to be considered in individual cases. There may be competing demands that will then be for the Secretary of State to weigh. But my Lord is right. That is the question which has to be asked and answered by the decision maker. So, my Lords, unless there's anything in particular in relation to the detail of what we've set out in relation to the respondent's notice, that's what I propose to say by way of oral submission on that issue. I then just briefly refer to the current statutory framework, so the impact of the 2023 regulations. And if your Lordship looks at that in the authorities bundle, tab 5 has the updated regulations. And if the court goes to page 95 of the authorities bundle, you will see the principal amendment for relevant purposes for today is paragraph 6(3) capital A towards the bottom of the page. So the Secretary of State may only include an amount under subparagraph 2B, and that's the ongoing fuel consumption, if the application is made by a person or body to whom payment is due, and B, the beneficiary consents to the application. So the effect of the amendment introduced through the 2023 regulations is that in relation to ongoing fuel costs, the consent of the individual is now required. And that doesn't apply in relation to water and doesn't apply in relation to arrears. If I can just invite you to look at the explanatory memorandum to those regulations, which is in the second supplementary bundle, page 18. And so I hope you have the explanatory memorandum there. Paragraph 2.2 on page 18 refers to the 2022 regulations. That was the temporary policy. And that was the position at the time of the hearing before Mr. Justice Kavanagh, that it was understood to be temporary. The regulations themselves were time limited and due to expire on the 6th of April 2023. And then paragraph 2.3 then refers to the 2023 amendment regulations designed to introduce permanent changes, and they're summarised there. Just interesting to note, given that both the Secretary of State's approach to interest and the judges, what's said at paragraph 7.4, first of all, page 19. A new approach to deduction requests will be introduced, providing more control to claimants. So that aspect of control and essentially flexibility. And then we see that echoed over the page in paragraph 7.9 on page 20. The temporary regulations were due to end on the 6th of April 2023. Due to the current energy prices and other inflationary pressures, the Department feels it is right that claimants have more autonomy to budget their income as they see fit. That's a recognition in our respectful submission of the importance of some of the factors which we'd identified in the court below, rejected by the Secretary of State and rejected by the judge. It doesn't, of course, render the claim academic because it only applies to ongoing fuel costs, but it does, in my respectful submission, undermine, to some extent, the arguments that are advanced on behalf of the Secretary of State and the interested party. And then, without going to it, we've addressed that point briefly in our supplemental skeleton argument. So our skeleton in response to Mr. Coppell's skeleton, paragraphs 15 to 19. I'm not going to take time reading those out, but it's the short submission made in relation to the relevance of the current new statutory framework, which we say does undermines to an extent the position being advanced. My Lord, in relation to Mr. Coppell's submissions, I don't have very much to say that wouldn't be repetition. Just in terms of the facts as they related to the respondent and what was said to be prior opportunities to agree payment plans that were not accepted by the respondent. If your lordships look, and I'm not going to go to it, but it's my Lord's note 50 to 51, paragraph 50 to 51 of Mr. Grice's statement. As we understand his statement, there had been no particular payment plan proposed prior to the 2015 deductions and one payment plan proposed prior to the 2019 deductions. It obviously doesn't affect the outcome of the substantive issues, but just in terms of accuracy and my client's position. And then the second factual point was the submission, which I think Mr. Coppell repeated orally, that the payment plan that the respondent has now entered into is the same offer that had been made to her previously. That is not correct, if that was what was being said. If I've misunderstood or misheard, my apologies. The position in terms of what is agreed now in relation to arrears is that the respondent pays 23 pence per week off her arrears, as opposed to what would be £4.24 per week at the current rate in relation to third-party deductions. In terms of the offer that had been made to her by Severn Trent Water prior to that, we've set out the figures in our supplemental skeleton, paragraph 7. I don't think I need to repeat the figures, but we've set out the figures there. The only payment plan offer made earlier that the respondents can identify is one that was in fact higher than the third-party deductions alternative, but certainly is materially higher than what she was ultimately agreed. But there's no other particular point arising out of Mr. Coppell's submissions. In relation to the issue on costs, I can take this perhaps even more briefly than the perversity challenge. We say this is mere disagreement with a discretionary conclusion that the appellant dislikes. There's no error of law. We've referred in our skeleton to the case of Islam and Ali. For my Lord's note, it's in the Authorities Bundle, tab 11, page 276, paragraph 20. There's no identifiable error of law in the approach taken by the judge to the question of costs. He was in an ideal position to identify where the justice of the position lay, who had in substance won. We've set out in our skeleton argument under this head references to the detailed submissions that were before the judge on the issue of costs. You have all those references in our skeleton argument, and I doubt it would be useful for me to take the court's time now in taking you to them. I think the one point that Mr. Sheldon made orally was that the points we failed on took up significant time. We don't accept that, and indeed that was one of the submissions we made to the court below, and that's set out in paragraph 66 of our skeleton argument. My Lords, might I just turn my back to see if there's anything further? Yes. No, my Lords, we invite you to dismiss the appeal on all grounds and to conclude in relation to the respondent's notice that the judge's approach to interests was too narrow given the legislation.
Thank you very much.
My Lord, just so that I'm not having the last word, Mr. Sheldon's invited me to make my few points. Just 3 points, if I may. First point is my Lord has a question to Miss Richards in the course of her submissions regarding the significance of the 25% cap on deductions, which my Lord says, and we agree, recognises that there may be other calls on the family's income which are more important than the priority debts. But we draw a rather different conclusion from the existence of the 25% cap and invite the court to do so. Our conclusion is that the legislator has already struck the balance as between what should be available for deductions and what should be left to the claimant in a manner which is no doubt calculated to leave sufficient income for the claimant to live on, bearing in mind that certain liabilities are already met. And that, we say, cuts against the relevance of a further argument at the interests stage that even within the 25%, that there are more important things which the claimant should wishes to spend their money on. The second point, in response to Miss Richards' reliance on the position of the claimant as somebody who is unlikely to be taken to court because she has no resources, and that then being a highly material factor to whether the deductions are in her interests, she could just carry on and let the debt continue to accrue. I would just draw attention to the second half of paragraph 10 of our skeleton argument and the logical consequence of that submission, which is that the category of customers who, on the claimant's case, are least likely either to pay their debts or to meet their ongoing liability for water charges and other charges should effectively be excluded from the deductions regime, because it won't be in their interests since they don't face the risk of enforcement action, it is said. We say that would be a very surprising result, not consistent for the reasons the judge gave with the statutory purpose. And the third point, and a very small point, and whilst I don't, there's the way that both my learned friends, I think, have put the effect of deduction is that money is being taken away from the benefit claimant. And of course, I accept in practice they have less benefit paid to them than they otherwise would. But the way in which the legislation treats it, and rightly so, which is in Regulation 35 on page 71 of the authorities bundle, is that payments are made to third parties on behalf of the benefit claimant. So it's not simply your benefit is reduced and we, the Secretary of State, are going to pay off this debt or that debt. The payments are, as a matter of law, made on their behalf. So it's the Secretary of State using their benefit.
Well, it would have to be, otherwise it wouldn't discharge the debt.
The point is it is on behalf of and to the benefit of the
And I suppose that it might be rational to assume that the amount of benefit that is paid to people includes an element in its original calculation, not formally, designed to pay utility bills.
Yes.
So what the Secretary of State is doing is taking away and applying to that course what was originally intended for it, up to 25% in total.
Lord, it is absolutely the case that the make-up of benefit, that some element of that is for utilities, water, fuel, etc. It's a complex process, but yes,
Yes.
undoubtedly that is part of the calculation. Thank you.
Thank you very much.
Just doing some changes of scenery. My Lords, I just make a few points in reply. I won't take up the allotted time.
Reduced as it has been.
Reduced as it has been, but my Lords, I wish to endorse the first proposition made by my learned friend Mr. Coppell about the 25%, 75% balance. My submission is the proper way to read paragraph 186 in Mr. Justice Cavanagh's decision, which was subject to criticism by Ms. Richards, is that he's saying don't take into account the other debts when they have already been taken into account with the 75%, because the whole purpose of the whole structure of the scheme is that we're only dealing with 25% when no consent is given. So when he's talking about interest, he's saying the interest within that 25%. Outside of that 25%, of course, the other debts and the other ongoing obligations will need to be met, food and so forth. And then also to echo what was put by my Lord Justice Edis, of course, heating and water will be part of the complex process that the Secretary of State considers when deciding what are the relevant subsistence payments, because they are subsistence payments. And the analogies with asylum support, I know we're not here dealing with asylum support, but where accommodation is provided, which includes fuel and water, that affects the amount that is paid to asylum seekers, because they are already in accommodation where they don't need to make those payments.
Surely 25% and 25%, 75% can can only be the broadest brush assessment of what percentage of benefit might be allocated to the particular utilities in question. And one of the things which may be the interests of the family is designed to ask the Secretary of State to consider is whether this family, because of its particular makeup and commitments, may need to have a different split, such that 25% would not be in their interests.
And my lord, when one is considering the TPD with respect to fuel, they may well not be anywhere near 25%. The 25% is only kicks in with respect to the individual fuel TPD if they are spending 25% of their income on fuel. There will obviously be a reason why they're spending 25% of their income on fuel. But I do accept it is a broad brush, but it's a balance that's been struck by the Secretary of State and through the regulations. Second point, my lord, in case there was any misunderstanding of the way I put the case before, my learned friend referred you to Lord Justice Sedley's comments in the Refugee Legal Centre case that's quoted in Citizens UK, where there's a reference to you mustn't sacrifice fairness on the altar of speed and convenience, a typical Sedleyism, which is very, very resonant. That was not my, and I think, my lord, you put it to my learned friend that was my case. Well, certainly she accepted that was my case. That is not my case.
I think I suggested that she might be saying that was your case.
And I wish to disavow that. That's not my case.
I thought
my case was that the reason for, one of the reasons not for having representation in advance was actually to assist others so that there isn't the delay for all the decision making, because one is on the representations. But feeding into that, and maybe what could assist, is the idea that my lord raised yesterday and that I thought to discuss earlier today, which is that the supplier, when they are sending the letter informing the benefit claimant that the TPD is being sought for, include in the letter, if you have any further information to provide, send it to the Secretary of State. If you'd like to make representations, make it to the Secretary of State. Here's the address, etc. The test is as follows, which is the interests of the family test. Because if that is then received at what would otherwise have been the same time as the TPD application, then that minimises the delay point and therefore minimises the impact on third parties. And why that is relevant to our argument is because we say if that is done, that shows you that the guidance is capable of lawful implementation. Because all of the court's concerns, I appreciate you haven't made any decision yet, but if your concerns, as echoed through your dialogue with counsel, are around, well, tame side and fairness and so forth, that would be resolved, because all relevant information that anyone wanted to put forward could be done at that stage, and the guidance does not prevent that. In fact, the guidance would allow and requires all of that information to be taken into account. That's why we were saying this is capable of lawful implementation. There's nothing in there which prevents that from happening. It would be very different if the guidance says you can only hear information in the following ways. Then, and I think my final point, my Lord Justice Edis, you asked a question around the application for revision, what we colloquially call mandatory reconsideration.
Yes.
My reading of the statute, I just need to find it again, Social Security Act 1998, it's page 12 in the authorities bundle. Section 9. The first reference in that section to application is at 1.1b. So the decision may be revised either on an application made for the purpose or on his own initiative. So that means there is an application made by the benefit claimant. That's what the application is. And then in making a decision, the Secretary of State need not consider any issue that is not raised by the application. So it's referring back to the application for revision. So if an individual writes to say, I don't like this TPD being made, these are the reasons why it's not in the interest of the family, then that, even if that hadn't been before the initial decision maker, it is captured here and must be taken into account by the decision maker on mandatory reconsideration. So they're not confined to what was known by the decision maker at the original time. And we say that supports the argument for fairness for all the reasons I've already given.
And I think there are also some regulations, aren't there, at page
and then there'll be
117,
regulations as well thereunder, which will amplify that.
provide some procedural
Yes,
rules, if you like, for dealing with these applications.
Absolutely, my lord. So, my lords, unless there's anything else you want to ask me.
No, thank you very much.
Well, I'm sorry to rise again, but may I just provide my answer to Lord Justice Edis's question to Mr. Coppell, because my answer differs, and it's not a point that was raised with me. The question about how benefits are set, and whether they're set effectively to take into account an element for fuel or water. I'm just going to read the note passed to me by my learned junior who lives and breathes welfare benefits, and then refer to one other matter. So this was Mr. Royston. The computation of benefit rates has never been done on the basis of calculating specific amounts for specific needs. The Secretary of State tends to reject any suggestion that it should be very fiercely because it would show benefit levels are inadequate. And I've just checked, there's a House of Commons briefing paper called How Benefit Levels Are Set, April 2022. Happy to share it with my learned friends in case it becomes relevant. But the passage I read, page 8, people often think that benefit levels in the UK are determined by an official assessment of how much is enough, by, for example, regularly costing baskets of goods and services considered essential to meet minimum needs. This is not the case. Benefit rates in the UK have never been based on any regular systematic estimate of minimum needs. The last and only time an official exercise was undertaken to determine the adequacy of benefits was in the 1960s. The results were not published and its impact on policy was minimal. So that's the House of Commons briefing paper on the topic.
Thank you very much. Well, thank you to all counsel for their submissions and the teams beside them and behind them for a very efficiently dispatched appeal. It won't surprise you to know that we're going to reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors who details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible, and if they can't agree it, to file written submissions so that an order can be finalised at the same time as hand down, and hand down will be notified the date for it and will be electronic only. Circulation to the parties or to any other person for the purposes identified in the Counsel General for Wales case will be the responsibility of solicitors. Any such circulation is for those purposes only, and any other publication, as I'm sure you're aware, may be a contempt of court. Thank you all very much.
All rise. In this area, in a way no one else sees.
Somebody, I think it was the Minister of Social Security,